Hey, what's up, everybody? This is a quick lesson from the Triumphs and Travails of the Jeffersonian Republic. Call this episode 4, and the objective of this particular segment is going to be to understand how, despite his strict constructionist viewpoints, Thomas Jefferson's administration was pretty much responsible for the expansion of the federal court system. We'll be taking a look at the Judiciary Act of 1801, the Supreme Court case of Marbury versus Madison under the leadership of Chief Justice John Marshall, and how the federal courts took on the power of judicial review. The story of Marbury versus Madison and the expansion of court power is a complicated one, but if you can understand this particular story and how the courts take on the power of judicial review, which elevates them to a third co-equal branch of government, then you're going to be not only doing really well in American history, but you are set up to dominate government class as well when you get to be a senior. So, from the outset, as we know, the Democratic Republicans were strict constructionists. That means that they believed in a rigid interpretation of the Constitution, one that would limit the power of the national government to what is only written there in the constitutional document. When Jefferson comes into power, he's already fearful of an expanding federal role, and so one of his chief competitors or antagonists is his cousin, John Marshall. John Marshall had been appointed as Supreme Court Chief Justice by the previous administration, John Adams. Over the course of his career, John Marshall is going to be elevated to the status of most important Chief Justice in the history of American jurisprudence. He serves for over 34 years under various presidents. He is widely respected for his intellect and personality. And as we will see in this particular unit, he shapes the American legal tradition more than any other figure. Okay? He is a committed Federalist. And this is something that Thomas Jefferson does not appreciate, at least from the outset of his presidency. Ultimately, what we have to understand here about strict construction of the Constitution as far as the court system goes, the courts are very narrowly defined in the Constitution itself. It's one of the smaller sections, Article 3. It gives the courts the power to hear cases that deal with constitutional interpretation, treaties, in situations where the U.S. government is a party. So, for example, the United States versus somebody else. It prevents the government from being sued. So usually with court cases, you'll see that a lawsuit names a person within the government and not the government as a defendant itself. It arbitrates controversies between two or more states, between two citizens of two states, and between the United States and foreign countries. But what the Constitution does not do is give the court some kind of power that makes it co-equal to the other branches of government. So the legislative and executive branches, we know that they're co-equal because they each have a check and a balance over one another. There's nothing written in the Constitution that gives the Supreme Court the power to overrule the other two branches. By the end of this unit, we're going to understand how the power of judicial review, that is the power to declare an act of Congress, the executive branch, or a state unconstitutional, we're going to understand how the court gets that power. But this is not in the Constitution, yet it is the most important judicial power the courts have. It's with John Marshall and the court case of Marbury versus Madison that the court takes this power for itself. So here's John Marshall as a young man. He attended a few weeks of legal lectures at the College of William and Mary. That's his only formal education. And yet Marshall goes on to prove himself as a brilliant Chief Justice. So the story of Marbury versus Madison and how the courts get the power of judicial review begins in 1801. Actually, it begins in 1796, but I'll get to that here in a minute. But for our purposes, we're going to say that the story begins with outgoing President John Adams and the Federalist Congress. So seeing the writing on the wall, knowing that the Federalists are going to lose the White House, Adams passes the Judiciary Act of 1801, which creates 16 new federal judgeships. So, in other words, 16 new courts are created with the very limited amount of time left that President Adams has in office. He, as the president, has the power to fill them all. Okay. Adams signs these commissions for federal judges, and they become known as the midnight judges. The reason for this being is that Adams and his administration are literally handing out these contracts at the very last hour of his presidency. The person that he assigns the responsibility of getting these contracts out is his Secretary of State, John Marshall. Now, John Marshall is the first to receive a contract. John Marshall is given the contract to become the U.S. Supreme Court Chief Justice. So as soon as Adams leaves office, Marshall's going on to bigger and better things. But with the remaining hours of the Adams administration, he's handing out contracts. He even gives some to his brother-in-law to take care of. But this is going to make anti-federalists, Jefferson's administration, very angry at the Federalists for packing the courts or filling these vacancies with Federalists, because as you should know, judges serve for life. Unless they're impeached, nothing removes them from their position except the will to resign or retire. Okay, so in the very end of Adams' administration, they're handing out contracts to these midnight judges. One of those judges is a D.C. court judge by the name of William Marbury. Marbury had been appointed or was supposed to receive a contract to become a justice of the peace in Washington, D.C. But it's one of the contracts that when the clock strikes midnight is still not delivered. And so John Marshall, his brother-in-law, have to set the contracts down because now the authority of the Adams administration is over. And now it's up to the responsibility of Thomas Jefferson and his incoming Secretary of State, James Madison, to deliver the contracts. Well, of course, Madison turns to his boss, and Jefferson says, leave the contracts lie. Leave them on your desk. Don't hand them out. We will fill these spots with Democratic Republicans. So when William Marbury comes and knocks on the Secretary of State's door to find out why he hasn't received his contract for his little position in Washington, D.C., Madison pretty much tells him that the opportunity, the offer has been revoked, and wishes him a nice day. Marbury, not wanting to settle with that response, sues the Secretary of State. This particular case, because it deals with contracts, ends up going before the Supreme Court as part of its first court case. So not very often do you have the Supreme Court hearing a case first. Usually it's an appellate case, but this is where we get to 1789. Okay. The reason that this case goes before the Supreme Court, this lawsuit goes before the Supreme Court, is because earlier in the Adams administration, the president had approved another little bit of legal legislation, the Judiciary Act of 1789, that says that the Supreme Court has primary responsibility over disputes on federal contracts. Okay, so it basically gives the Supreme Court primary jurisdiction over these kinds of matters. Okay, so not the Constitution. Constitution doesn't say anything about Supreme Court hearing matters of contracts as a primary jurisdiction, but the Judiciary Act of 1789 does. I hope you're still with me. So, courts oftentimes break legal arguments down into legal questions. So, in this next slide, what I'm going to be doing is presenting the legal questions John Marshall poses for the court and the answers he gives in addressing them. So, Marshall, a Federalist, is looking at this case and he is concerned because he knows that his actions, a court's decisions, have to be carried out, and judges don't carry out their own decisions. The executive branch is responsible for carrying out decisions, and he knows that if whatever his orders are, it will be the responsibility of President Jefferson to carry them out. Jefferson, a strict constructionist, is bound to take any decision that he doesn't like and ignore it. And this is going to make the courts look incredibly weak. And Marshall doesn't want that. So Marshall's crafting of this argument literally will determine the future, the fate, and the prestige of the U.S. Supreme Court system. Up until this point, it had been a place with very little impact. So the first legal question Marshall addresses is, does Marbury have the right to his appointment? Okay. Should he receive the contract? And to this, Marshall answers absolutely yes. Yes, the appointment was signed and sealed by President Adams. It carries the weight of law, and he gives President Jefferson a dressing down for being so immature and petulant about following through with his responsibilities. Okay. But number two, do these laws of the country give Marbury a way to have things set right? Does he have the ability to sue Madison in order to get some kind of compensation or get this job? And once again, the Marshall Court says, yes, Madison broke the law, and there's a process for fixing this problem that is the responsibility of the court system in general. So question number three, is asking the Supreme Court to fix this problem the correct solution? Is Marbury in the right place? Right? The law, the Judicial Act of 1789 says he should be taking this lawsuit to the Supreme Court first. And to this, the Marshall Court says no. The Constitution does not give the Supreme Court original jurisdiction in this matter. So he turns towards strict construction of the Constitution to answer this question. It's not written, and so no, this is not our affair. Furthermore, Marshall goes on, Congress cannot change the court's jurisdiction without amending the Constitution, which it did not do. So passing this simple little flimsy law, the Judiciary Act of 1789, to change the scope of the power of the courts is unconstitutional, right? It cannot be enforced as law. So we see here the very first use of judicial review. But here's the irony. It checks Congress. It says the law Congress passes is unconstitutional. Why is this ironic? Because nowhere in the Constitution does it say the courts have the power to declare an act of Congress or the president unconstitutional. So in one hand, Marshall says we can only do what the Constitution says we can do. And in the other hand, Marshall says, I'm sorry, but Congress cannot change the scope of the courts, and therefore this is unconstitutional. This is implied. Okay, it's controversial, but Jefferson had no other option than to accept it. I mean, what is he going to do? Say, no, I made a mistake, Mr. Marbury, here's your contract? That would make him look foolish. And the other regard, there's nothing he can do to change court precedent. And so Marshall has established, enthroned judicial review into the legal precedents of the court and elevated the court to a co-equal branch of government. Now the courts, because of Marbury versus Madison, have the ability to check and balance the other two branches. So what does that look like? Well, in some cases, the courts can overrule decisions of elected officials. These decisions might be popular. For example, we see with Brown versus Board of Education, the courts will declare segregation unconstitutional, even though segregation was the status quo and many people supported it. Once the court makes a decision, it acts as common law. So even though Congress has never passed a law that protects the right to abortion, the Supreme Court case Roe versus Wade establishes the precedent that it is a woman's right to privacy that protects her decision-making when it comes to getting an abortion up until the end of the second trimester of pregnancy. In conclusion, judiciary review has become an implied power of the judicial branch that elevates it to the same level as the executive and judicial branches.